Marco, the due process element of this as well. To get a warrant to go to someone's home, to search their home, there's a very clear procedure. And yes, you can get a no-knock warrant, but that's the exception. But a lot of the digital element of this as well is essentially a no-knock warrant, and you're not going to be notified that your data is under investigation, that there's a search of your data, and you have no really right to defend yourself. Is that how it works?
Yes, sometimes can be a problem because in some countries, definition of electronic evidence is there, and then they have proper measures, and then the measures also include conditions and safeguards. When you can do that, on what conditions, and then how the procedure, and then whom you can send a request. But very often it is not the case. Necessary provisions, legislative provisions, they're not there. And therefore also, as there is no common standard, then this also has led to a situation that countries have taken their own initiatives, and they have drafted and adopted their own policies and provisions. This is also something new instrument might try to solve, to agree on proper conditions and safeguards.
But there's a sense of, I don't want to be unfair, but American exceptionalism, that you will do as you're told in some cases. And in the law enforcement of digital data, that seems to be pretty apparent, and there's no rollback from this. Do you think John's argument that they lose this case, the United States government will begin to soften its approach, will begin to look for more partnership?
It is difficult to say, but on one hand, very often providers, also sometimes country, they rely on principle of territoriality, that if the data is stored in one particular country, then this is the legislation, this is the jurisdiction that would apply. But it's also that if a provider is offering services also elsewhere, and then they are targeting customers, providing services, sort of economical presence in a country, then again, if a company is providing services in a country, then one could also ask a question whether a company should obey national laws, and then if those laws prescribe that lawful requests from law enforcement need to be served, then. But yeah, we do have a conflict of interest in jurisdictions here.
Catherine, on this issue as well, you may propose from the Commission something which is vaguely agreed by Council, but do you have any sense that Parliament would accept something which didn't have reciprocation in it? And if you bear in mind the PNR discussions and the fights over that, but TTIP as well, if America's not giving Europe the rights, Europe and Parliament in particular is not inclined to reciprocate either. So do you see this fight going the distance, or is it going to be a short agreement?
No, I mean, I think we need to distinguish this from PNR, and TTIP is a completely different one, but also PNR. We're not talking about bulk data transfers here. I mean, let me be very clear. We're talking about specific investigations in criminal cases, access to specific pieces of information. We're not talking about mass transfer, mass surveillance, or anything like that. And I think the Parliament also has an interest and has shown an interest in strong fundamental rights protection. And I'm not sure that the present day system actually managed to ensure this. So I think we're going to have a very interesting and probably very detailed discussion with the member states and the Parliament, and it's for them, not for us, to decide what will be the solution in the end. But I think there is a fairly constructive attitude all around, and the Parliament also recognizes that there is a certain challenge that needs to be solved, and closing down the conversation is probably not the best way forward.
John, there's a public perception, I would say, that when you talk about searching international databases, that it's a national security issue. A lot of this isn't national security, but is the national security argument used too often?
I don't know if it's used too often, but I think it is helpful to talk about practical scenarios and when this is, and I think that a lot of this is sort of gut judgments of people about, does that feel right, and are you comfortable with that? And so I think that having a discussion among broader groups about what is our collective sense, and ultimately that is what parliaments do, right? But if you think about the simple case of, okay, a French court issues a search warrant for the email content of a French citizen, in principle, it seems I'm okay with the French court getting that data, provided you don't have a conflict of law along the way. And so the way to deal with that is having an agreement so that whether the data is stored anywhere in European Union, the countries agree that that court order can be served on us, and it may be stored in Dublin, it may be stored in Paris, but we can provide it. But we need a legal framework that permits that. And similarly, we think about, when we have an EU-wide agreement, that makes it much easier to have that transatlantic agreement with the U.S. so that that French customer's data stored in the U.S. or in Dublin or in Paris, we can comply with that French agreement. I think most people would say, I would guess people would say that's okay. And I think in these things you can also get a lot of edge cases that are much more difficult, and lawyers love the very complicated. I think just solve the easy part first and see how it goes, learn from it, and then build out.
The British agreement with the United States on this issue as well, it already has more or less what you describe. And so if the British government wants to search the data of a British citizen in the United States, that's pretty okay. But if they want to search an American citizen's data in the US, that doesn't happen.
Correct. Then you have to go through an MLI. I mean, there's the backdrop for a lot of public perceptions about this are framed by the Edward Snowden disclosures, right? And we all kind of, that rocked us all. And the White House was rocked as well, but the statement that came out was, don't worry, Americans, we only spy on foreigners. That was great for about 13% of our customers worldwide. The other 87% weren't feeling so good. But we do, we trust our own governments on these privacy issues because there's a sense of political accountability if they screw up. Now, we don't trust foreign governments the same way we trust our own. And I think it's just a reality. And so as we think about solutions here, you want to know that your own government and your own protections are still going to apply.
Catherine.
Yeah, it's just, I fully agree with John that of course we have the most faith in our own government because that's what we're familiar with. But actually that has nothing to do with where the data is stored, because that might be anywhere. And as long as we look at that as the primary factor, we're going to run into issues both with the country that wants access and with the country of citizenship or residency or whatever you want of the person whose data is being requested. And I think that's really the key issue that we're going to need to deal with, is how do we deal with data storage location as a connecting factor. I think some countries have decided that should be the key one, and they have adopted data localization requirements, which is also not the best way forward.
I think that's a terrible approach. I mean, we have the potential here to go one of two ways. We can recognize that data is everywhere, but national borders are still the foundation of international law. And we can work with international law and say countries need to reach agreements on this. And that's the way to do it. And if we do that, I think people's personal protection, privacy protections, fundamental rights, and due process can be protected. But if we go the other way, which is every country just says, well, I'm just going to assert it. Borders, I don't care. Then we find ourselves in a world of conflicts of law where there's not due process and there's not privacy protections because there's just an assertion of jurisdiction unilaterally. And I think that, this discussion's been taking place for a while, but we're at this critical moment of like, are we going to go towards international agreement or just on people doing it on their own? I just don't think it works to have countries trying to go it alone.